Hi guys, we'll be discussing on one more very important topic, that is sexual offense. What is sexual offense? It is sexual activity or sexual intercourse or sexual interference with a person or with an animal, right? Against the law, against the provisions of Indian law, unlawful, you call it as offense. Right, this topic is indeed important. That is because, irrespective of the specialty that belong to, maybe you're a forensic medicine expert or you're a pediatrician or OGCN, you would have to be examining the people who are involved in this kind of offense. For example, like you will have to examine the survivor of sexual assault, that is victim, or you would also have to be examining sexual assault accused as well. Right? See, sexual offense is basically a heinous crime in India, and you can see the prevalence is more in India, right? As a doctor, you as a medical examiner, like you will have to medically examine. You are involved in medical examination. You are involved in medical legal examination. You are involved in the treatment of the survivor, and you're also involved in the collection of evidences, timely and appropriate collection of evidences. See, all these sequence is very important for the all these things should be appropriate so that it will aid in the investigation process, subsequently in the justice. Right? If there is any problem with any of these steps, if the chain is broken in any of these things, suppose if the doctor doesn't know what evidence to be collected, or if the doctor has collected the evidence properly but he has not preserved it properly, he doesn't know where to forward it, all these things will have serious consequences in the trial. Right? Serious consequences in the investigation process and in the trial as well. And there are so many instances where, right, lot of cases where the High Court and the Supreme Court has commented on the poor quality of the doctor with regard to this. So adequate knowledge, appropriate knowledge, sound knowledge on this topic is highly, highly important. Here we'll be learning on the various laws associated with these offences, and we'll also be learning about the legal provisions with regard to your examination of accused, examination of victim, and what are the evidences that are important, right? So all these things we'll be discussing in this particular topic. Fine. Let us start with the classification. This is basically an older classification, but let's see the concept, right? And let me tell you then why it is less relevant nowadays. Right? Classification, you can say it is natural sexual offense. You have unnatural sexual offense, right? You have sexual paraphilias, also called as perversions, and then we have sex linked offenses. Sex linked offenses. So these are the four important group that we have got. Natural sexual offense means it is as per nature. What is nature? Peno-vaginal. Right? Peno-vaginal. Right? Unnatural sexual offense, it is against the order of nature. Against the order of nature. Order of nature. That is unnatural. Right? It is not peno-vaginal, something else. Right? Paraphilias, it is there is no intercourse here. The person does not have intercourse, but still he gets a sexual gratification by something else. He does not get he's not involved in sexual intercourse, but he gets a gratification by something else, by some other activity. We'll be discussing in detail. Sex linked offenses, you can remember, it is indecent assault. Right? So that is again one of the example of sex linked offense. Right? So this classification, older classification. Nowadays, it's very less relevant. I'll tell you why. Number one, when there is a modified, updated definition of rape, right? When there is updated definition of rape, so this classification has become relevant, right? The second important thing is when the Supreme Court has decriminalized 377 IPC, that is unnatural sexual activity between two adults. The Supreme Court has decriminalized. So that is making this classification again less relevant. Even latest also, the NMC has issued a circular stating that these kind of this unnatural sexual offense better not to be, right? Better not to be used. Fine. But for understanding purpose, for conceptual purpose, we are just having a brief look on it. Fine. So now you can see that what all comes under peno-vaginal, right, offense. That is your rape. You can say it is adultery and incest. We'll be having a detailed discussion of each of these conditions, so do not worry about that. So against the order of nature, you can say sodomy, buccal coitus, right, buccal coitus, lesbianism, and bestiality. Right? Fine. And perversion, there is a long list: exhibitionism, sadism, masochism, all these things we'll be discussing. And we also, I told you, the indecent assault is one of the example of sex linked offenses. Right? So this is what that you have to know. This is basically what you have to know. Right? And now we'll be discussing each thing in detail. To start with, the first thing is rape. Right? But do remember, guys, the rape is basically not a medical definition. Do remember, it is a legal definition. It is a legal definition. I have seen many cases where the medical officers have written the opinion like this victim, she so and so of so many years is raped. Right? You are not supposed to use the word rape in the medical certificate that you issue, in the medical legal report that you issue. Remember, it is a legal definition. It is not a medical definition. Even in many of the students, like while you are issuing sexual assault case victim certificate, like in your practical exercises, I have seen so many students are writing the same thing, like I am of the opinion that she has been raped. You are not supposed to use this. Again, I am reiterating the same fact that rape is a legal definition. It is not a medical definition. Remember, it is a legal definition. Fine. But let us discuss something more in that. See, it is definition of rape is given by 375 IPC. The letter D refers to definition. Right? So this was an updated definition that we are going to see, which was just updated in the year 2013 after Delhi rape case. Right? Delhi rape case, Nirbhaya gang rape case, it happened in 2012 December. Right? I guess it is 16th of December 2012. Right? After 1 month of that incident, like 2013 January, the Indian government has modified, right, many of the laws related to offences against women. Remember, offences against women. Right? Not only rape, many offences against women. That was called Criminal Law Amendment Act. The entire criminal law amended as on 2013 January. Right? As on 2013 January. And many of the laws many of the sections, legal sections which are associated with the offences against women were completely modified. In that, even the rape definition is also modified. So let us have a look at the new definition. Fine. Here, a man is said to have committed rape on a woman whenever there is penetration of penis into the vagina, into the anus, into the urethra, or into the mouth, to any extent. That is very important. Right? To any extent. To any extent. Right? It is the insertion of any of his body part. It is the insertion of any of his body part or any foreign body, FB means foreign body, into the vagina, right, into the anus or into the urethra, vagina, anus, urethra. Or if the person has manipulation of the body part of the female to cause penetration, body part of female to cause penetration into the vagina, anus, urethra. He is not directly penetrating it, but he is manipulating the body part of female so that the penetration will happen. Right? Vagina, anus, urethra. And not only that, if there is any application of his mouth, he is applying his mouth into the vagina of the female, into the anus of the female, or into the urethra of the female, all these act will amount to rape. All this act will amount to rape, provided if it is done against the will of the female, against her will, right, or without a consent. She is not willing, against her will, right? She may be willing or not, but she has not given consent, without a consent, right? Or he has got consent from her, but the consent was given due to fear of hurt or death. Right? She was threatened, right? If you're not giving consent, I will kill you. If you're not giving consent, I will hurt you. Right? Keeping a knife on his neck and threatening. She has given consent. That is not valid consent. Or this hurt or death is on a person whom she is interested. The accused is keeping a knife on the neck of his husband, asking consent. If you are not giving consent for sexual intercourse, I will kill your husband. Right? Like that. In the fear of hurt or death for her or any other person whom she is interested, consent is given. That is not a valid consent. Not only that, if the consent is given, right, believing that he is her husband, but it was not her husband. There was impersonation. She thought he is someone whom she is legally married, right? But in reality, that there was impersonation, he was someone else, right? That consent is also an invalid consent, right? Or when the consent is given due to insanity, she is insane, mentally ill, given consent, right? Or if it is due to intoxication, she was completely under the intoxication, alcoholic intoxication or any other drug, she was given drug, she got completely intoxicated, and in the intoxication state the consent was obtained, that is invalid consent, right? Or influence, right? All these consents are invalid consent. We have already learned that in 90 IPC. I told you consent given under insanity, influence, intoxication, that is invalid consent. The same thing is applies here. This consent happens to be an invalid consent. Or if she is under the age of 18 years, and the last one is if she is unable to communicate, she is not able to communicate, right? But still you assume that she has given consent, right? So under all these conditions, if a person is doing any of this act, this will amount to what is called as rape, right? This will amount to what is called as rape. So this is again very, very important, right? Now the point is, see, you can see the updated Criminal Law Amendment Act 2013, right? 2013. I told 2012 Delhi rape case, and this was in the year 2013, right? Fine. Now let's go forward. So who's the accused, who is the victim in sexual offense and in the rape? You can see accused is always a male, right? Victim is always a female. Why is it like that? You can see this is a male offense. You can see the first line of 375 IPC. A male is said to have, a man is said to have committed rape, provided if he has done any of these acts, right? Under these many conditions. Fine. So always male accused, female it is victim, right? A woman can never be charged for the offense of rape, right? 375 IPC. So do remember accused is male. Now when you talk about the age, right? What about age? There is no specific limit with regard to victim, right? You can see cases in all the age group. With regard to accused, again there is no specific age limit. There is no age limit for accused, right? In all the age, again we get cases. But again, if they ask you, the question is like this: what is the minimum age limit for an accused in a case of rape? There is no age limit. But if they ask you what is a minimum age under which the accused in a case of rape is not punishable, right? There is a difference. Not punishable in the sense, as per 82 IPC, a person less than 7 years of age is not punishable for any offense, including rape, right? So if the person is not punishable, nothing is an offense committed by a child less than 7 years. We know that is 82 IPC, right? When it comes to no age limit, there is no age limit. When it comes to punishment, it's not punishable under 7 years. So you need to look at the question very carefully and answer accordingly. That is again very important. Now let us move on to other important question. Right? If the person says that there was only a partial penetration, there is no complete penetration, will it amount to rape or not? Yes. Even for that, you need to look at this explanation. For the purpose of this section, vagina shall include labia majora. That means even the slightest touch of the penis in the labia majora will be considered as rape. Right? For legal purposes, even the slightest touch of the penis in the labia majora will be considered as rape. So you cannot say there is partial penetration or no penetration. In reality, if you look at the definition, it is not only penetration of penis, it is also inserting any object, body part, manipulation of any of his body part, applying the mouth to the vagina. That means even technically speaking, even a person without penis can also be charged with the offense of rape if he has done any of the other activities. Right? So that is the point that you need to understand. Right? So now what about the minimum age? What about the minimum age? Right? Let us say one patient has been brought to the casualty with complaints, and you have to do some medical intervention wherein you need to do per vaginal examination. And she is only 16 years old, less than 18 years, right? She is minor, right? She cannot give consent for sexual intercourse, right? Will that be Let us see another practical question. One female patient has been brought to the casualty for some complaint, and you had to do per-vaginal examination. Either she's not interested, right, or if she's not interested, you can't do examination. Suppose she happens to be a minor small child. Now this kind of per-vaginal examination, will it amount to rape or not? Because you're inserting finger, right, inserting finger, will it amount to rape or not? For that you need to have this particular exception. What does it say? Exception 1: a medical procedure or any intervention shall not constitute rape. That does not constitute rape, right? Medical procedure or intervention, because you are doing it for the benefit of the patient. That doesn't contribute, that doesn't state that it is rape. It doesn't constitute rape. And the second important point is, now the question is, what is the minimum age for giving consent, right? For that, have a look at this second exception. Sexual intercourse by a man with his own wife when she is not below 15 years, it is not rape. This was the exception given in 375 IPC. But in 2017, the Supreme Court of India has mentioned that sex with a minor wife is a rape. Right, sex with minor. Even basically this exception is controversial because as per Indian law, the minimum age for marriage itself is 18. When it is less than 18, obviously it has to be punishable, but this is one controversial exception. For that, the Supreme Court has given in 2017, sex with a minor wife is also amounting to rape, is an offence, provided the female lodges a complaint within 1 year, right? Fine. So for that, with taking that into account, if you talk about the minimum age for giving consent in sexual intercourse is 18 years, irrespective of the marital status. So what you have to remember is basically only one number, that is 18 years, right? One number, that is 18. Now, when you look at this, suppose a boy is 18 years old, he is having his girlfriend 17 years, 16 years as consensual sexual activity. Consensual, right? With the consent, is having sexual activity, sexual intercourse. Is it a punishable offense or not? Right? Is it an offense or not? It is an offense. We call this as statutory rape. We call this as statutory rape. Right? Sex with a girl less than 18 years, right? Less than 18 years without her consent or with her consent, doesn't matter. The consent doesn't matter because anyway she is under 18 years. So it amounts to what is called as statutory rape. Do remember, it is called statutory rape. You need to remember the minimum age is 18 years. The minimum age is 18. So we have discussed about the definition. Now we'll be discussing about the punishment for rape. 376 IPC gives you the punishment of rape. We have got 376(1). We have got 376(2). We have also got 376(3). Right? 3 subsections are there. When you talk about the subsections, so you can see that 376(1) gives you the punishment of rape. The minimum punishment is 10 years to life imprisonment. Right, 10 years to life imprisonment. The minimum punishment itself is 10 years. Earlier it was 7 years. Now it has been revised into 10. Right? And what about 376(2)? 376(2) is the one that gives punishment of rape under, right, more aggravated situations, or you can say special situations. There are a lot of subsections under this. Right? Not everything is so important for examination purpose. You can see that it starts with A, it goes up to M. It has got lot of subsection. Custodial rape, when the rape is on a pregnant woman, when the rape is during communal violence or any kind of sectarian violence, when the rape is done on a woman who is suffering from mental illness. So many subsections are there, but for you to answer the examination purpose, in the examination purpose, what you have to remember is only one important point. This section also gives punishment for custodial rape. Right? This section also gives punishment for custodial rape. Fine. You know what is custodial rape? Rape in the custody of a police or any other authority. Fine. So this is what you need to remember for examination purpose. Now moving on to 376(3) IPC, this states punishment for rape on a girl who's less than 16 years of age. 16 years. Right? Basically, you don't have to know all the individual punishment for each section. So we are not studying LLB or we are not studying law degree, like we are basically studying MBBS. So what is so important for examination purpose? It is enough for us to know that alone. Right? Punishment, basically, you don't have to worry about that. right? Now let's talk about the extensions. What is that? We have 376A. 376A gives you punishment of rape, right, resulting in coma, the victim becoming comatose state, victim turning into comatose state, or the victim suffering from persistent vegetative state because of rape, right? Because of rape resulting in coma of the victim or persistent vegetative state. 376AB. What is that? 376AB gives you punishment of a rape, right, of a girl less than 12 years of age. I told you 376 is for 16 years, now it is 12 years. 376B, this is one very important section, right? Punishment of forceful sexual intercourse, by a husband, right? By husband. I told you by husband means with wife. By husband with wife during the phase of separation. That is so important. During the phase of separation, right? What do you mean by that? So this section is very important. This section is very important because this section is many a times misunderstood as marital rape. Do remember, it is not marital rape. It is not marital rape. Here, the husband and wife is there. Husband and wife are there. They have filed a case of divorce in the court of law, right? And they are living separately. When they are living separately, husband goes there and has got forceful sexual intercourse with the wife, right? When he has got forceful sexual intercourse with the wife during the phase of separation, then it is punishable. Right? So that is given by 376B. And it is not marital rape. Do remember, there is no concept of marital rape in India so far legally, right? And then we have got 376C. What is that 376C? 376C states that sex by a person, punishment for sex by a person in authority, right? It is not rape, it is sex by a person in authority, right? If the person is in a authority state, sex by a person in authority, it is not custodial rape. Here the person is in authoritative position, using his position, you can say misusing his position, is inducing or seducing a woman to have sexual intercourse, right? Is inducing or seducing a woman, a female, for sexual intercourse using his position, right? Using his position. So that is punishable under 376C. Here the concern, what is the basic difference between custodial rape and 376C? 376C is, let us assume the person is one authoritative position. Under him, the female is working. This person is telling that if you have sexual intercourse with me, I will give you this promotion, or I will do this favor for you, I will allot this project for you, something like that. For that particular benefit, the woman has got sexual intercourse with that particular person, right? The female has got sexual intercourse with that person, and for the benefit of that favor, right? After that favor, the female will lodge a complaint against that fellow, and this person is punishable under 376C. Right? Now, I also told you custodial rape. What is the difference between custodial rape and this 376C IPC? The consent matters. Right? Here, the female has given consent for sexual intercourse for the benefit of that favor. Whereas in custodial rape, it is forcefully done. There is no consent. That is a basic difference between custodial rape and 376C. Right? 376D. 376D states that it states the punishment of gang rape, right? Rape done by two or more people, right? Acting in further common intention. 376DA, punishment of gang rape of a girl less than 16 years. Right? More punishment, severe punishment will be given. 376DB, punishment of gang rape of a girl less than 12 years. 376E, 376E. What is a 376E? Punishment of rape or by a repeat offender. Earlier he was convicted of rape, right? He is undergoing punishment, or he has completed his punishment, right? This person is again committing rape on another girl, or same girl or another girl, right? Repeat offender. Accused is the same person. Repeat offender. Earlier he was convicted of rape. Again he is committing a rape on another girl or the same girl. That is punishable under 376E. Right? So you can see 376A, AB, B, C, D, DA, DB and E. All these sections. But if you honestly ask me, all these sections are so oriented towards legal thing, but what you have to understand is two important thing. Number one, 376B and 376C, right? 376C, seducing a female under custody, right? Or 376B, forceful sexual intercourse by a husband during the phase of separation. This is what you need to remember, right? So let's go forward. What are the other legal provisions and other legal sections that we have to know? Number one, the first important section, which is now we are going to see the sections which are directly relevant to medical practice. Number one, 357 CRPC. Right? It is not IPC, that is CRPC. It tells you the procedure and the guideline. It says that all the doctors must give first aid treatment to whom? To victims of rape and vitriolage. Immediately. You cannot waste time. Immediately, right? Free of cost, and police intimation to be done by the doctor. To be done immediately, right? So this is given under 357 CRPC. This is highly important, right? Highly important. You can see this section itself, whatever I've written, this thing itself has got multiple keywords. What is the keywords? Every doctor has to treat, irrespective of whether you're working in a government setup or semi-government setup or private hospital or your own clinic. Doesn't matter. You cannot say, this is my private clinic, private hospital. You go to the government hospital, get treatment from this. This is a medical legal case, go to the government hospital. Can a doctor refuse treating a rape victim like that? Can a doctor refuse treating a vitriolage victim like that? Never. It's not no, never, right? You can't do that. You can't do that. Fine. And you need to give at least first aid treatment. You may say that this is a private clinic, I don't have the adequate facility to treat the victim of rape and vitriolage, but still no problem. Give at least first aid treatment. And you can't waste time. You have to immediately give, and you can't say that you need to pay this much for getting treatment. It has to be given free of cost. Right? And it is the burden on the doctor to give police intimation immediately. Right? You cannot ask the victim to go to the police station, file an FIR, then come, I'll treat. It's not like that. Right? And do remember, if any of the doctor is violating this, if any doctor is not treating the rape victim or vitriolage victim, right, refuses to treat this victim, that is punishable under 166B IPC, right? At least 1 year imprisonment can be there, right? 1 year imprisonment can be there. Do remember, the punishment is not basically so important, but look at the sections. Section is important. Punishment for not treating as per 357C CRPC, that is highly punishable. It is so relevant for your medical practice, right? If you're a doctor in your hospital, when any such victim has come, you need to know it. Not only ethical duty to treat the victim, you've also got legal duty to treat the victim, right? So that is why it is so important. Now, what is the next section that we have to know? 228A IPC, right? This is IPC, right? We tend to shift towards IPC, CRPC, but let me keep highlighting then and there what it is basically we are discussing. Here we are discussing about IPC. Here what you have to know is, this is the section that gives punishment for disclosure of identity of rape victim, right? So you are not supposed to disclose identity, maybe in the name, maybe the photograph. That's why if you see any media which is publishing the news about any sexual assault case, they don't publish the photograph of the victim, or they don't specifically mention the original name of the victim, because they are not supposed to do it. Any kind of disclosure, right, by anybody is punishable under 228 IPC. This is so very important. 228A, right? 228A, disclosure of the rape identity of rape victim, that is punishable. That is punishable. Right? There are so many cases where, right, the courts have given punishments for the media agencies for disclosing the identity. Right? And nowadays majority you don't see any kind of disclosure, because it is barred. They are barred from doing it by this 228A IPC. So the next section is 327 3 CRPC. What is that 327C CRPC? This is basically in camera trial, right? In camera trial. The trial of rape cases should be under in camera trial. What is that in camera trial? The trial of this case, court proceedings will be conducted in a closed chamber. Conducted in a closed chamber. Right? Closed chambers only. The public and the media, press media people, they are not permitted inside. Public and the press media people, they are not permitted inside. It has to be not allowed inside. It has to be conducted in closed chambers. That is in camera trial 327-2 CRPC. Right? What is the next section? Next section is about presumption of consent. Right? What is that presumption of consent? That is given by 114A IEA, right? 114 IEA, that is Indian Evidence Act, right? This is Indian Evidence Act. This act states that, see, now this case is there, but in this case, the sexual intercourse between the accused and victim is proved. There is no question about that. There was a sexual intercourse between the accused and victim. Right? That is proved. And now the question is, it is only about whether the female has given consent or not. That is only the question. Right? The sexual intercourse has occurred, no problem. But here, whether the female has given consent or not, if that becomes the question, and in the court proceedings, if that female comes to the court of law, mentions that she has not given consent, the court shall presume that she has not given consent. Right? Now the burden of proof of innocence lies on the accused. Right? Do remember here, if the female is stating that she has not given consent, the court shall assume that she did not consent. No means no. Right? Fine. So this is very important section 114A Indian Evidence Act. But if the question is whether the sexual intercourse had occurred or not, that's a different situation. Now here the sexual intercourse has occurred. It's only about the consent. If it is only about the consent, well, if the female say that she has given consent, the court shall assume that she has given consent. Right? So that is 114A Indian Evidence Act. We'll move on to the medical examination of rape accused and rape victim. Right? Medical examination of rape accused and rape victim. Right? So this is so important for us. Right? This is very, very important for us. So we'll discuss about that. If you talk about medical examination, let us say accused. Right? Let us say survivor or the victim. Right? We can say survivor. That is the ideal, appropriate word. When you talk about accused, do remember the sections which are associated with that. I'll tell you the sections related to that. I'll tell you what are the tests that we have to do, what will be the finding of the test, right? Which are so important for your examination purpose, right? Many a times, particularly in INICT examination or even in NEET PG or next whatever exam, so these sections are continuously being asked in different permutation combination. For that, you need to know this section. Let us see. The first section is 53A CRPC, right? 53A CRPC. It is about examination of rape accused, under police request, not below the rank of sub-inspector, not below the rank of SI. Suppose if this examination is done under 53A CRPC, if the examination is done under 53A CRPC, remember the examination can be done using reasonable force. Right, using reasonable force. The law states that if the examination of rape accused is done under 53A CRPC under the request of the police, not below the rank of sub-inspector, you can do that examination using reasonable force. But how much reasonable, the law has not mentioned. Using reasonable force, we imply that in these kind of situations, the consent is not mandatory. Consent is not mandatory. Fine. So this is 53A CRPC. There is one more sections associated with the accused, that is 54 CRPC. What is that 54 CRPC? It states that it is about examination of the accused as per his own request. Examination of accused under his own request. Right? Under his own request to prove that he is innocent, he is not guilty. Right? So 53A CRPC under police request, 54 CRPC is about his own request, examination of accused under his own request. Right? If he is requesting, obviously, definitely the consent will be there. There is no question about that. Let's talk about victim. Right? If you're talking about victim, do remember it should be done under 164A CRPC. This section is highly relevant, highly important. So remember 164A CRPC, very important. Fine. If you look at the provisions of this section, here the section becomes so important, the consent becomes so important. Consent is mandatory. You cannot do this examination, you cannot do the victim examination without the consent of the victim. No examination without consent. You can underline it, right? You can take a note of it. Right? Not only in your notes but also in your mind, right? So you should not do any kind of medico-legal examination, right, without the consent of the victim. So when you're trying to examine the rape victim, when you're trying to examine the rape survivor, you are asking the consent before starting with the medico-legal examination. Now the victim is denying, no, I don't want to undergo this examination. No. Right now you are trying to explain the purpose of this examination. You are trying to tell the intention that this is meant for collection of all these evidences so that it will be useful for the investigation process and subsequently conviction of the case. Right? Still, if the victim is not willing for this examination, you cannot force her. But what you have to do is you need to get what is called as informed refusal. Right? You need to get what is called as informed refusal. Get the informed refusal form signed from her. That is very important. Informed refusal has to be obtained. But just because you get informed refusal from the victim for medico-legal examination does not mean that you should not give medical treatment. No, medical treatment can be given. Medical treatment should be given. Medical treatment is to treat the victim. Medical treatment should be given. Right? If she has got some injuries or any other problem, you need to give even psychiatric counseling should be given. All this medical treatment should not be hampered, should not be stopped just because she has given informed refusal. Right? So that is again very important for you to learn. While you are doing this examination, you can use a kit that is called safe kit. Sexual assault forensic examination kit. Right? The safe kit can be there. You can use that for the examination of the victim and for the collection and the preservation of all the evidences that are needed for the examination. Right? Fine. So now let us see what are the different tests that we can do. What are the different tests that we can do? First, let's discuss about accused, then we'll be moving on to victim. If you're talking about accused, do remember one important examination that we'll be doing here, that is called Lugol's iodine test. Do remember, friends, it is called Lugol's iodine test. This test is basically to find out, to detect, to demonstrate vaginal epithelial cells. Right? We'll discuss about it. But I'll tell you what you have to do here. What you have to do here is you have to take right? What you have to do is you need to take swab. You need to take swab from the penis. Take a swab from the penis, right? Expose it to iodine vapor. When you're exposing it to iodine vapor, you can take a swab or you can take a filter paper. You can wipe it on the penis, right? Then expose that paper, expose that swab to the iodine vapor. When you're exposing it to iodine vapor, you will be getting brown color. The presence of brown color, when you are able to see the presence of brown color, that means the test is positive. Right? That means the test is positive. That confirms the presence of vaginal epithelial cells. Right? Vaginal epithelial cells. Now you can ask me, sir, vaginal epithelial cells will be in the victim. Then why do you want to do this test for the accused? Do remember, guys, Locard's principle of exchange. Locard principle of exchange states that whenever there is a contact between two surfaces, there is an exchange of material between two surfaces. The material from this surface will go to this surface. From this surface will go to this surface. Exchange of material. Whenever there is a contact between the male genitalia, female genitalia, there can be an exchange of the material from the female genitalia onto the male genitalia. And the vice versa. Right? There can be exchange of vaginal epithelial cells from the female onto the male, right? And you do this test for the male genitalia. If it is positive, you confirm there was a contact. You're going to prove there was a contact. And do remember, this test can be positive up to 4 days. Right? This test can be positive up to 4 days, provided he has not completely washed it. That is again very important. Right? So the first test that we have done in the accused is Lugol's iodine test. The second important finding that you have to note is the presence of smegma. What is that smegma? Do remember, the smegma is a cheesy secretion presenting in the glans penis. It normally takes, whenever there is a complete penetration. Whenever the complete penetration, the smegma would have been wiped off. And it normally takes 24 hours for the smegma to be resecreted. Fine. Now the question is, let us say one accused is brought. And the police history is telling that this person has committed a rape, complete penetration was there less than 6 hours back. You are doing the medical legal examination. While you are doing the medical legal examination, you are able to see the smegma in the glans penis. Now, you know very well, now whenever there is a complete penetration, smegma would have been wiped off. You also know that it will take at least 24 hours for the smegma to get resecreted completely. Now, in this fellow, there is smegma present. What does it mean? When there is a presence of smegma, that excludes the possibility of rape within the last 24 hours. Right? When there is presence of smegma, it excludes the possibility of complete penetration. Excludes the complete penetration, right, in the last 24 hours. Right? So that is why this finding becomes significant. Right? This finding becomes significant, and it is significant only in a case of complete penetration. And you all know that the complete penetration is not needed for the person to be charged of rape. But still, if the history says that there is a complete penetration, and if you are able to see smegma, that excludes complete penetration within the last 24 hours. Right? So that is the point that you have to understand. Now, we were talking about the accused. Now we'll be talking about victim. In the victim, the one important is, accused, we did the Lugol's iodine test. In victim, what we can do? In victim, what we can do is what is called as toluidine blue test. Right? Toluidine blue test. What is this toluidine blue test? This is basically, it comes as a spray. It's a dye. It's basically dye, blue dye. What you have to do is this test, first you need to understand what is the purpose of doing this. What is the purpose of doing this? It is to detect recent micro injuries. It is to detect recent micro injuries. Remember, micro. You can't see that so clearly with your eyes. Right? Recent micro injuries. You need to use this. Suppose, see, whenever there is a victim, survivor is brought for medical legal examination, you are examining, there may be a possibility of small injuries in the vaginal cavity. Right? These micro injuries cannot be visible in the naked eye. So if you want to make it visible, you take that blue dye, toluidine blue dye, spray it, Wait for some time. You can be easily seeing that micro injuries, provided if it is recent. Right? So this test will tell you the presence of recent micro injuries. Toledo blue test. Remember, Toledo blue test, we are using it to detect recent micro injuries. One of your previous AIMS question. Now, during examination, what are the findings that are important in victim examination? First important thing is, let us take a swab. That is so important. Right? If you want to, see till what time that you can take swab. If you want to detect the presence of spermatozoa, right, 3 days, right? Or if you want to just look at the presence of seminal, right, trace, then it is 4 days, right? 3 days, 4 days, spermatozoa. You are able to see the spermatozoa, and you can also find out the sperms are motile. That's a very important sign. That is a very important sign. Presence of motile spermatozoa. Presence of motile spermatozoa, that indicate it is a recent rape. That is again very, very important. Recent rape. Because the motility, remember, the motility will be seen only up to 6 to 12 hours. If you are able to see the motility, that means it is a sign of recent rape. Recent rape. Fine. So do remember, we have discussed about Lugol-Sadin test, we have discussed about Toledo blue test. I have also told you what is the most, the presence of what is the most important significance of the smegma in accused, and I have also told you about the swabs and the presence of motile spermatozoa. That's a sign of recent rape, and this has been asked many times in your examination. The next condition that we have to discuss is adultery. What is adultery? Adultery is basically male having sexual intercourse with the wife. You can ask me, sir, that is normal. Here, it is a wife of some other person, another man. Right? It is a wife of another man without his connivance, basically without his consent. Right? A male having sexual intercourse with the wife of another man, that is called adultery. Earlier, it was punishable under 497 IPC. Right? Let us assume there are 3 people. One is Raju, another one is Ramu. Ramu got married to Rani. If the Rani has got sexual intercourse with Raju, this is an offense, that is adultery earlier. In which case, the Rani will not be punished, but the Raju was punishable. Raju was punishable. Right, as per 497. But recently what happened, the Supreme Court has scraped this 497. The Supreme Court has mentioned that Raju is not punishable. You can see that this is 497 IPC. Adultery is no longer a criminal offense. Right, 497 IPC is scraped off. Right, 2018, few years back. In that particular case, you can see there are few highlights of the verdict that I've brought so that you will understand it better. CJI, Chief Justice of India, Deepak Mishra told that the adultery can be a ground for divorce, but it is not a criminal offense. Underline the point, it can be a ground for divorce. Right? It's a ground for civil case, not for criminal case. At the same time, you can also see mere adultery cannot be a crime, but if any aggrieved spouse, either the wife of Raju or Ramu, if any agreed spouse commits suicide because of this adultery and they produce evidence, this could be treated as abetment of suicide. They can book the people under abetment of suicide, that is 306 IPC. Right? Abetment of suicide. Right? It's a ground for divorce. It can also be irrelevant to abetment of suicide. That is why it is important. Adultery can be treated as civil wrong for dissolution of marriage. That's why we discuss it is for a ground for divorce. Right? CJ also said that equality is the governing principle of the system, that husband cannot be the master of the wife. The women cannot be treated as commodity belong to one particular person. That is why this adultery 497 IPC has been scraped off. Adultery might not be the cause of unhappy marriage. It could be the result of unhappy marriage. This is another observation of Chief Justice of India in that particular verdict. Right? So do remember here, Raju is not punishable. Adultery is legally not punishable offense. But at the same time, Ramu can file in the case Civil case for divorce, right? Legal separation, right? That can be a ground for divorce. He'll be given divorce. If suppose Raju commits suicide, if Raju commits suicide, in that situation, both Ramu and Rani will be punished for abetment of suicide if they have got sufficient evidences for that particular case, right? So do remember, this is adultery. Now we have one more important condition, that is incest. Right? Incest is basically sexual relationship between blood relation, closely related blood relations. When I tell you closely related blood relations, we can say it is father, mother, daughter, son, but doesn't stop with that. It also includes granddaughter, grandson. You can see auntie, uncle, all these people will be considered as incest only. Now I told you that father, mother, son, mother, father, daughter, son, mother. Right? We have basically three complexes in incest. Incestuous complex. What are that? If there is a relationship with the sexual intercourse between father and daughter, if it is between father and daughter, that is called Electra complex. Right? It is called Electra complex. If it is between mother and son, in that case, it is called Oedipus complex. Oedipus complex. If it is between brothers and sister, if it is between brother and sister, then it is called as pharaonic complex. Right? It is called as pharaonic complex. You have got Electra complex, Oedipus complex, pharaonic complex. All these are amounting to incest, incestual relationships. This incest is basically not punishable. There is no specific law. Incest as such as is not punishable if it is between adult and done with consent. Right? Remember, if it is between adult and it is done with consent, incest as such, it is not legally punishable. But if it is done, if any of this thing is done without anybody's consent, if there was a forceful thing, then it is punishable. It is treated as an offense. Right? It is treated as an offense under 375 IPC. Suppose if the father has got sexual relationship with the daughter is a minor, in that case, the father can be booked under 375 IPC. Right? 375 IPC. In case if the mother has got sexual relation, Oedipus complex with son happens to be a minor, you know very well the mother cannot be booked under 375. Can the mother still be booked under? Yes. Now the mother will be booked under POCSO Act, Protection of Children from Sexual Offences Act, wherein the 375 does not come into play. Why POCSO Act? Because I told you the example, son happens to be minor. Right? If the brother is having forceful sexual intercourse with the sister, then brother can be directly booked under 375 IPC, right? That is 375 IPC rape. So the point is, if it is between adult and if it is consensual, it is not punishable. This incest as such, there is no specific legal section in India. It's not punishable. It is not punishable. Now let us discuss other conditions. We have discussed about rape, we have discussed about incest, we have also discussed about adultery. Let us go to the other areas where so far we were discussing about penile vaginal intercourse. So far we are discussing about penile vaginal intercourse. Now we'll be discussing about other conditions where there is no penile vaginal intercourse. When there is no penile vaginal intercourse, what are the conditions that we have to discuss? Right? We'll discuss. Number one, that is sodomy. Right? What is sodomy? This is penile anal intercourse. This is penile anal intercourse, that is sodomy. Right? Penile anal intercourse. It may be between male and female. It may also be between male and male. Right? Sodomy. Fine. But here you can see that there may be an active agent, there may be a passive agent. If you talk about active agent, let us say active agent. Active means active agent. Passive agent. Right? Let us assume active agent is an adult and the passive agent happens to be an elderly person. Right? This condition is called as gerontophilia. Geriatrics, gerontophilia. Elderly person, right? Gerontophilia. Adult, same accused. We have not changed the accused. Accused is the same fellow. But now he is changing the victim. Who's the victim? It's a male child. Right? Pediatric fellow. Right? The victim happens to be a child. In this case, this condition is called as pederasty. Fine. If it happens to be a pederasty, see, pederasty is basically a condition when there is an habitual sodomy, between an adult and a male child. In this condition, the adult, the accused, will be called as pederast, right? Pederast. Whereas the victim will be called as ketamite. They'll ask you, there was one exam where they've asked you who's ketamite. Ketamite is a passive agent in pederasty. Passive agent in pederasty, that is ketamite. Right? So you know it is penile anal intercourse. Right? Now, what are the findings that you can notice? What are the findings? It may be the findings will differ whether the victim is an habitual victim or the person is a non-habitual victim. Suppose if this is the first time, it's a non-habitual passive victim. The person is non-habitual passive victim. The first time there was an act of sodomy. What are the findings that you can notice? The first finding is there can be pain and tenderness in the anal region, perianal region. And when you are examining, you can see the presence of semen as well. Semen can be noted from the accused. And particularly if it happens to be the first time non-habitual passive agent, you will be able to find out the presence of injuries that may be abrasion, there may be bruises, there may also be laceration. There may also be laceration, which is typically present in a non-habitual victim. Particularly around the anal opening. We are talking about all the findings near the anal area. Right? Now you need to see the anal fissure. Anal fissure is very much possible. Particularly in the posterior quadrant. That is very important. Posterior quadrant, it is very much possible in the anal region. Anal fissure. Now, hematoma. You can see a collection of blood in the perianal region, that is hematoma, collection of blood in the perianal region, hematoma. But here you can see because of that collection of blood, because of the hematoma, normally what you see is around the anal region, you can see the anal and skin fold will be there. That is normal. Right? Normally you see the anal fold and the skin fold in the anal region, but because of this blood collection, what happens is that entire fold obliteration of the anal and the normal skin folds. You will not be able to see the folds at all because of the blood collection, and this sign is called as Steyr sign. Fine. So these are all the findings that you can see in a person who's non-habitual. Suppose if the person happens to be an habitual victim, I told you this ketamite is an habitual passive agent. This person is a ketamite. If this person happens to be ketamite, while you are examining, see in a non-habitual patient, as you open the exam, as you are examining the perianal region itself, the person will be having severe pain and tenderness. But this fellow, habitual passive agent, there is no pain, there is no tenderness because he got habituated to the penetration of penis. He got habituated. There is no pain at all. The perianal skin. This perianal skin, the passive agent, there can be, you can see the shaving of the skin, shaving of the hair will be there in the perianal region. Not only that, if you look at the perianal region, there can be thickening and the keratinization. And the keratinization of the skin can be noted. That is because of the constant rubbing, constant friction. Keratinized skin and the thickened skin can be noted in the perianal region. Right? Look at the anal sphincter. It is loose. It is patulous. It is lax. It is patulous. There can also be loss of rugae. Right? Loss of rugae in the anal sphincter. Right? That is because it is due to repeated activity. There is something called lateral traction test. What is a lateral traction test? When you see, normally this examination is done when the patient kept in knee elbow position. Right? When you see this person, the anal sphincter, normally when you hold the gluteal region, you give traction, mild traction laterally. When you give mild traction to the gluteal region laterally, on traction, what happens is normally you find a constriction. Right? There can be constriction of the anal sphincter. But for this person, right, there can be a relaxation of the anal sphincter. The anal sphincter will be relaxed. Right? And look at the shape of the anus. Sometimes it can be funnel shape. You can also see the funnel. Right? So all this is due to All this is due to habitual passive agent. All this is seen with habitual passive agent due to repeated acts of sexual activity in the anal region. Right? So that is a difference between a non-habitual person and an habitual person. That is what you need to remember. Right? Let's move further. We have discussed about sodomy. Then we'll discuss about what is called as lesbianism. Lesbianism is basically the sexual activity between two females. Two females. One person can be an active agent. Another person can be a passive partner. Passive partner and active partner. The active partner will be called as dike, whereas the passive partner will be called as femi. Right? Active partner will be called as dike, whereas passive partner is called as femi. And this lesbianism, see, whenever we discuss about the sexual offences and sexual perversions, the synonym becomes so important that you get a lot of questions basic from the synonyms. Right? So lesbianism is also called as tribaidism. Right? It is also called as sapphism. It is also called as sapphism. It is also called as tribaidism. These are the synonyms for lesbianism. Let me tell you the synonyms for sodomy. Sodomy is also called as Greek love. It's also called as Greek love. It is also called as buggery. Right? These are all the synonyms for sodomy. Let me tell you the synonyms for all the conditions. Right? So what is the next condition? Next condition is called as buccal coitus, which is also called as sin of Gomorrah. Buccal coitus. Basically, it is oral sex. Buccal coitus, oral sex, also called as sin of Gomorrah. Oral sex. Right? Oral sex. Fine. There can be oral stimulation. There can be oral stimulation of penis. Right? When there is oral stimulation of penis, it is called as, when there is oral stimulation of the penis, it is called as fellatio, which is also called as penilingus. Lingus means tongue. Stimulation or the male genitalia with the tongue, that is called penilingus. When there is a oral stimulation of the vagina, right, that is called cunnilingus. Right? Cunni implies vagina. Lingus means tongue. Stimulation of the vagina with the tongue, that is called cunnilingus. And then anus. There can also be stimulation of the anus with the tongue. Right? That is called anilingus. Right? Basically, it is lingus. Right? What is most important is lingus. Anilingus, cunnilingus, penilingus. All these are oral sex, buccal coitus. Now, one more important condition under this, which is called as bestiality. What is bestiality? It is a sexual intercourse with lower animals. Right? Lower animals. Lower animals means anything below the human beings. That is lower animal. Right? It is not just animal. Animal means human being. That is not that. Human being is also animal. That is not we're talking about. We're talking about the lower animals. Other animals like dog, cat, sheep, horse, all these things. Right? Fine. So these are all bestiality. This bestiality. Now, I have told you 4 conditions, which is not peno-vaginal. Number 1, sodomy. Number 2, lesbianism. Number 3, bestiality. Number 4, it is buccal coitus. All these are punishable or not? Earlier, it was punishable under 377 IPC. Punishment of unnatural sexual intercourse, carnal intercourse. Right? It was punishable under 377 IPC. But few years back, what happened? The Supreme Court has decriminalized 377 IPC. The Supreme Court has decriminalized 377 IPC. Now, these acts are punishable or not. Right? These acts are punishable or not. But you may think that it is not punishable. Right? Gay sex is not punishable. Lesbianism is not punishable. Buccal coitus is not punishable. Don't think like that. See, for that you need to understand what does the verdict say. See, as 377 be completely removed by Supreme Court judgment? No. The Supreme Court just said that sexual activity, right? Sexual activity between two consenting adults not punishable. Two consenting adults not punishable. But what does it mean? What do you understand from this statement, guys? What do you understand? The first point that you have to note is, if it is done with adult, it is not punishable. If any one of the partner happens to be a minor, that is punishable. First point. Second point, it has to be consenting. That means if there was a question of consent, if there is no consent given, if it was forceful, again that is punishable. Do remember, it is not completely removed. It is not scraped at all. That is wrong. You have to remember, if it is between two consenting adults, it's a private affair. We are not concerned about that. What we are more concerned is if it was forceful, right? If it was forceful act, or if it is done with a minor, right? Or you can say if it is done with animal, lower animal, then you can say it is punishable under 377 IPC. That is very, very important, right? You need to understand the concept. Fine. So we have discussed about all the four conditions, that is sodomy, buccal coitus, lesbianism and bestiality. Now moving further, let us talk about another important area, that is called sexual paraphilias, right? Sexual paraphilias. These sexual paraphilias also called as sexual perversions. These sexual paraphilias also called as perversions, right? Perversions, sexual perversions. When do you say a condition is sexual paraphilia? When will you say a condition is sexual paraphilia wherein the person achieves sexual gratification not by intercourse? There is no sexual intercourse as such. He does not get, right? The paraphilia may be associated with the act of sexual intercourse. That doesn't matter. The point here is the person achieves sexual gratification not by sexual intercourse, by any other method, right? He is obtained by any other method, then you can say that condition is sexual paraphilia. Lot of conditions are there. We'll be discussing one by one. Right? Lot of conditions are there. Number one, the person achieves sexual gratification by inflicting pain to the partner. He will beat the partner, bite the partner, whip the partner, lash the partner. Right? He will bite all the body parts of the female, particularly the breast and other sexual regions. He will bite. If the person achieves sexual gratification by inflicting pain to the partner, it is called as sadism. It is called as sadism. Right? Marquis de Sade. Marquis de Sade was a person who was involved in all these activities, and the term sadism is brought from that reference, right? Sadism. When the person achieves sexual gratification by suffering of pain, the person will request his wife to beat him, to whip him, right? By suffering that pain, this person achieves sexual gratification. That is called masochism, right? It's called masochism. Sadism, masochism. Sadism, masochism. One extreme form of sadism is called as lust to murder. What is that? Lust to murder. Here, murder is there. The person achieves sexual gratification, lust, for the purpose of lust, he is murdering the victim. The killing, see, there is a difference between rape and murder, lust to murder. Rape and murder, there may be an offense of rape, maybe to conceal it, to conceal the crime, murder might have been occurred. But here, lust to murder, the killing of the victim, death of the victim serves as sexual gratification for the accused. He is murdering the victim for the purpose of achieving sexual gratification. That is an extreme form of sadism called as lust murder, right? That is called as lust murder. Fine. So, extreme form of sadism is called lust murder, right? This sadism is also called as algolagnia. Algolagnia, right? Sadism. Masochism is opposite, right? So you call it as passive algolagnia, right? Passive algolagnia. Active, passive, right? This is one combination. One person suffers pain, another person, right, inflicts pain. Sometimes there can be together, they can be together. The couple, one person will be sadist, one person will be masochist. That's called bondage. Sadomasochistic activity, right? Both will be together. That is called bondage, right? Perfect couple. Then we discuss when the person achieves sexual gratification by displaying the private parts. When he displays the private parts, it is called exhibitionism, right? You can say the person displays, right? He's showing his private part, right? To whom he shows? Normally, it is due to non-consenting person. If it is between consenting person, that's not a question of perversion at all, right? That is not an offense at all. But here, it is normally the person derives sexual pleasure in showing his private part to a non-consenting person, to a stranger maybe something, right, to a non-consenting person or to a stranger. Right, even last year exam also, in one of your exam, NEET exam, you got a question like the person was sitting naked in the balcony facing the public park. Right, he was sitting naked in his balcony facing the public park and derives sexual gratification from that. What is that condition? The condition is your exhibitionism. Right, he is displaying, exhibit. The word exhibit means display. Is it an offense? Is it an offense? Yes, it is an offense. You can say 294 IPC. Right, so public nuisance, 294 IPC. Another important condition wherein the person achieves sexual gratification by watching the private acts. Watching the private acts of a female usually. Watching the private. What are private acts? As per 354 IPC, basically this act is called as voyeurism. Right, this condition is called as voyeurism. There is one separate legal section punishing this, that is called 354C IPC. We'll be discussing all the legal sections together, but now you need to understand this section associated with voyeurism is 354C. Right, 354C IPC. It states that as per this section, what is a private act? When do you say it's a private act? A private act is any act which a woman does not want the others to see. Normally getting taking bath, right? Changing the dress, right? Having sexual activity. Right? All these are private acts. If any person derives pleasure by seeing any of these things, you call it as voyeurism. This is also called as scotophilia. Right? Scotophilia. Right? We also call this person as peeping Tom. Right? He is peeping and achieving sexual gratification. The Tom is peeping. Right? That's called peeping Tom. Peeping Tom. Fine? You can see this is sadism and masochism. If this person achieves sexual gratification by inflicting pain, you call this as sadism. If this person achieves sexual gratification by suffering of pain, you call it as masochism. Together they form a couple, I told you, bondage. Right? The person achieves sexual gratification by showing his private part, undressing, showing, getting naked, showing. All these are exhibitionism. I told you that is punishable. Right, 294 IPC. This is the person who is peeping. You can see the person is peeping through the keyhole, looking at the female taking baths. Right, this is called as voyeurism. It's called as voyeurism. There is one condition that is called troilism. What is that? This is an extreme form of voyeurism where he experiences sexual pleasure by having his wife engage with sexual activity with someone else. He wants to see his wife having sexual intercourse with someone else, some other person. That's called troilism. Right? He achieves sexual pleasure by watching his wife having sexual intercourse. By watching his wife with any other person. Any other man. Troilism. Right? That's a form of voyeurism only. Then this is again exhibitionism. So this is another combination. One is exhibitionism, another one is voyeurism, peeping Tom. But in exhibitionism, do remember there are three important variants are there. You can say subtypes. Number one, that is called streaking. Right? What is that streaking? You could have seen in many matches and all, football match and all, what they do, rugby matches and all. People, they remove the dress, they run naked in the ground itself. Suddenly during the match, in between the match, they just run naked in the ground. That's called streaking. Running naked. Running naked. That's called streaking. That's a form of exhibitionism. That's a form of exhibitionism. This is another thing wherein the person removes the pant and shows the gluteal region. That is called mooning. That's called mooning. It's a form of, again, exhibitionism, showing the gluteal region. Right? Lowering the pants and showing the gluteal region, that is called mooning. It's again a form of exhibitionism. There is one more there wherein the person might be walking on the road. The person might be walking on the road, suddenly he'll remove the dress and show the private parts to a person and suddenly he'll close. Right? That's called just like a flash. Just like a flash, you call it as flashing. Right? This flashing. It can be seen among males. It can be also seen among the females. Females remove the dress and showing the breast regions. So suddenly this is called flashing. Flashing. So all these are basically different variants of exhibitionism. You have mooning, you have streaking, you also have flashing. All these are exhibitionism, variant of exhibitionism. What is the next? The person achieves sexual gratification by wearing the dress of opposite sex. The person achieves sexual gratification by wearing the dress of opposite sex. Usually, this is seen among males, wherein the person achieves sexual gratification by wearing the dress of female. He will wear the dress of female, he will wear the sari of female, he will wear the nightgown of the female, the inner wear, the brassiere, the pantyhose, all these things he will wear, and he derives pleasure out of it. When he derives pleasure out of it, do remember it is called eonism, which was on last year examination, which is classically called as transvestism. Right? It's easy to remember. Trans means opposite, vest means dress, transvestism. Vest means dress. Right? Transvestism, also called as eonism. Do remember the synonym. It is also called as eonism. That is important, which was asked in your examination. Fine. Right. So this is transvestism, normally seen with males. Also seen with females, usually seen with males. With inanimate object, the person achieves sexual gratification with inanimate object, non-living things. Non-living things. Or sometimes with some body parts. Right? Non-living things, inanimate object, or any body part. Any body part, which is not usually sexual. Which is not usually sexual. Right? When the person derives sexual pleasure by in contact with an inanimate object, any body part which is not sexual, it is called as fetichism. Right? Fetish. Again, he will take the dress of female, he will take the inner garments of the female, or he'll take the hair clip, the wristwatch, the bracelet, the mask, right? All these things, the shoes, right? The footwear, everything he will take. With that, he will have sexual gratification. He will derive sexual pleasure out of it. That is called fetichism. Right? That's called fetichism. Sometimes any body part which is not sexual. For example, the little finger. The little finger. Right? He will keep touching, he will keep licking, all this. He will fondle with this little finger and derive pleasure out of it. Right? Any body part. Any body part. The fingers, toes. Any body part which is not usually sexual. Fetichism. I told you transvestism, I told you fetichism. But what is transsexual? What is the difference between transvestism and transsexual? Transsexual is the people who don't derive sexual gratification by wearing the dress of opposite sex. They feel they are a part of the opposite gender. A male who's a transsexual, if he will feel that he is a part of female gender. That's why he's wearing the dress of female. It is not for sexual gratification. But here in transvestism, the person, he knows his gender properly. There is no question about that. But he wants to derive sexual pleasure by wearing the dress of opposite sex. That is why this person wears the dress of opposite sex for the purpose of sexual gratification. That is the basic difference between transsexualism and transvestism. Right? Transvestism. Okay. And I told you fetichism, there is one variant of fetichism wherein the person is more obsessed towards one body part of the body. Only one body part. That is called partialism. Partialism. One body part. Right? Partialism. Easy to remember. And I told little finger. He will always be obsessed towards the little finger. That is called partialism. Fine. The person achieves sexual gratification by rubbing his genitals. By rubbing his genitals against a female in a public place. Non-consenting female. Again, if it is consenting, there is no question of offense. This is an offense. The person achieves sexual pleasure by rubbing his genital against a female in a public place like bus, right? Crowded place like bus, temple. So you have so many places where they are crowded. And this person will always be there, right? Deriving pleasure by doing this kind of act. We call it as frotteurism. Frotteurism. Right? This is frotteurism. This is punishable basically 290 IPC, right? But it is actually punishable under 354A IPC. We have learned that 354A IPC amounts to sexual harassment. Sexual harassment, you have a lot of other conditions on sexual harassment. What amounts to sexual harassment? Even touching the body parts of a female without consent, that is amounting to sexual harassment. So this act can be considered as sexual harassment. You can book the person under 354A. 354A. Right? And what about fingering, fondling or licking? Fingering, fondling or licking, this is called uranism. This is a type of homosexuality. Male homosexuality, Uranism, right? So this person wearing the dress of female, so this is eonism, transvestism, right? Not usually punishable. He is not going to. Usually, it is this kind of practice is practiced in a private place, right? If it is causing public nuisance, maybe it is punishable. Or if he's stealing the articles from someone else, for stealing, it may be punishable, right? Inanimate objects. See, all these are inanimate objects, and it is fetishism. It is fetishism. This is frotteurism. I told you it amounts to sexual harassment. Remember 354A IPC, and you can also include 290 IPC, which was mentioned in older editions of the textbook. Right? Sexual gratification is obtained by having sexual intercourse with a dead body. That is called necrophilia. Philia means affection. Sometimes people will eat the dead body. They achieve sexual gratification, that is called necrophagia, eating the dead body. Phagia means eating, having sexual pleasure by eating the dead body, that is called necrophagia. They will cut the body part of the dead body, they'll eat it. Particularly the organs like breast, the thigh, all these sexual organs will be cut and will be eating. The person derives pleasure out of it. That is called necrophilia, necrophagia. Remember, both are punishable under 297 IPC. Right? Why 297 IPC? 297 IPC is giving punishment for causing any indignity, disrespect to human dead body. Disrespect to human dead body, indignity to human dead body. This kind of activity, having sexual intercourse with the dead body, right? That is punishable, causing in disrespect to the dead body. It is always punishable under 297 IPC. 297 IPC. Right? Talking obscenity. The person derives pleasure by always talking obscene things. That is called scatologia. Scatology. Sometimes the person suddenly takes a phone, he'll dial random number, he'll start talking obscene thing, derive pleasure out of it. Right? That is called telephone scatologia. If it is over phone, that is called telephone scatologia. Right? Telephone scatologia. This is scatologia. Talking obscenity. Fine. And do remember, this telephone scatologia is a form of exhibitionism. It's a form of exhibitionism. Right? Right. And then you have writing obscenity. Some people derive pleasure by writing obscene things. They write something in a public place. They'll write something in a public toilet. They'll write some row letters or poem obscenity, and they will send it to the people and derive pleasure out of it. That is called erotographomania. Erotographo, writing, mania, pleasure. Erotographomania. They'll keep talking, writing, all obscene things and derive pleasure out of it. That is called erotographomania. You can see this is necrophagia, right, which is punishable under 297 IPC. I told you, erotographomania, they keep on writing obscene things, send it to people that they want, right, whom they want to send. That is called erotographomania. Talking obscenity, that is telephone scatologia. Over phone, that is called telephone scatologia. Sexual gratification obtained by the sight or smell of urine. They'll keep seeing the urine, they keep smelling the urine, they always think about urine. That is called urophilia. Right? They get excited, right? They get a sexual gratification by seeing or smelling the urine, by the thought of urine. That is called urophilia. The person sees or smells the feces. That is called coprophilia. Right? Urophilia, coprophilia. Urine means urophilia, right? Feces means coprophilia. Right? Coprophilia. This urophilia is also called as undinism. Right? Urophilia, undinism. Right? The synonyms that we have to know. So have knowledge about this. Sight or smell. They keep smelling, they keep seeing the urine. They keep smelling the urine or feces. They keep seeing, smelling. All this is urophilia and coprophilia. Right? We have one more condition that is called Bobbitt syndrome. What is that Bobbitt syndrome? Bobbitt syndrome is wherein there is male genitalia amputation. Male genitalia amputation. Right? By whom? by the doctor for any therapeutic intervention? No. It is a male genitalia amputation by the female partner. By the female partner. Right? The female partner is cutting the genitalia of the male. That is called Bobbitt syndrome. Many a times it is done for infidelity. Infidelity. Right? Extramarital affair. Right? Male genital amputation by the female partner, we call that condition as Bobbitt syndrome.